Hey guys, how is everyone this morning? I hope everybody had a good evening last night. I have good news and I have bad news. The bad news is we may not be done with Dr. Bodden this week. That's the bad news. But the good news is why we might not be done with Dr. Bodden this week. We have a new trial today. Yay! So, at the end of this stream, it will redirect you to the trial. The trial is in Iowa. I might regret this because of the time difference. The trial starts at 10. So, that's going to push it. If they go all the way to the end of the day, which would be 5, that's going to make it 6 for me. Oh, I can. Hey, Carla. Hey, Jill. Hey, Judy. Hey, Terry. So, if it goes till 6, then we can just raid Biggin. Yeah, that's a good plan. That's what we'll do. Okay, so Judy gave us some trivia. Eric Poticha is a producer, writer, co founder, and CEO at Frank Poticha Productions. Poticha was a senior vice president of the Jim Henson Company. Cool. Sorry, guys, I'm drinking Pepsi again. Prior to working for Henson, Poticha served as VP of Movies and Miniseries at Fox Television Studios. Poticha left Henson and was a principal at In Vogue Films, an entertainment consultancy firm. Cool. I love Jim Henson so much. I love the Muppets. I really, really do. I'm really sad that they took the Muppet 3D movie out at Disney. That movie was so good. It was so good. And Statler and Waldorf were behind you in the theater. Like it was a movie, but they were in the balcony behind you heckling during the movie. It was so fun. I loved it. I'm going to miss it. And I wasn't able to go see it before they took it out. I've not seen it in 18 years. Yeah, 18 years and now it's gone and I didn't get a chance to go see it. My one of my favorite Christmas movies is the Muppet Christmas Carol. I love the Muppets. I love the Muppets. My family doesn't care for the Muppets. Um I don't know, maybe it's cuz I grew up with Sesame Street maybe and like my stepkids didn't because Sesame well they did, but there were other things that came along. Like, when I was a kid, Sesame Street was it. There was no all this other alternative Barney and Bluey and like all these things that teach the kids stuff nowadays. Like it was Sesame Street, Electric Company, Romper Room, Captain Kangaroo, but they weren't on all the time because there was no streaming back then or video. It was just you watched it when it came on and that was it. So I guess maybe that's why those kind of things are like formative for kids. For people my age, they were like formative because it's like you had to make an appointment to watch it. Like you had to be there. Whereas now kids just watch whatever, whenever. It's so like the Muppets are like they have a special place in my heart, because so anyways, don't get me started talking about the Muppets because I will I will bore you to tears because I love the Muppets. Okay, so we've got 2 hours, an hour and 45 minutes before the new trial starts. So the first part we're doing is only 5 minutes long. I don't understand, but it's only 5 minutes long.
All right. You may resume whenever you're ready.
Dr. Button, thank you for returning. Get my stuff here. I want to show you, we were talking about Ms. Clarkson at the scene, and basically what happened at the scene when remember what those procedures are that occur when a medical examiner or coroner's office move a body? Done?
In general, yes.
Okay. And in this particular case, or let me ask you, is it usual for a coroner's office or a medical examiner's office to document what they're doing so that later on, if there's ever an issue, you can go back and look and evaluate that to see if there's any question or issue as to how the body was moved and what was done?
In general, yes.
Okay, and in this particular case, did you review the reports and notes of Jamie Lintamoot, one of the criminalists for the medical examiner's office or the coroner's office for Los Angeles?
Yes.
Okay, and did she describe in the her report and her notes what she did at the scene insofar as Lana Clarkson's body was concerned?
Yes.
Does she talk about in preparation for the body being moved, whether or not there was something put over the head in some fashion?
Yes, I'm referring to a report that she made out.
Your Honor, I would ask the doctor kindly to answer the questions that he's asked based on his memory until it's established that he cannot remember and he needs to refresh his recollection. Just
All right.
a matter of
Okay,
protocol.
I'll put this away. Yes, Ms. Lintamuth did remove certain evidence from the body, nail scrapings and other evidence, and then mentioned.
You know, AJ's not wrong. Like, that is the way they're supposed to do it. But it almost comes off sounding like, not petty, but like tattletale-y. Like, he's not following the rules. You know what I mean? Like, I don't know. It just kind of comes off weird to me. I mean, he's not doing anything wrong because that's true. That's not the proper protocol for refreshing your memory. You can't testify from a report. You can't read a report into the record. You have to do it from memory unless you don't remember. And then the attorney's supposed to say, would it refresh your recollection if you looked at the report? And then you're supposed to read the report to yourself and then say what it says. But it's kind of like when Alan Jackson's like, objection, Your Honor, and then says he has to do it this way. It's kind of like, it reminds me of like a kid tattling on their sibling to their parents, It just, I don't know, like, I don't know any other way for him to do it, but it just seems like he's tattling.
Mentions a concern about whether to remove clothing at the scene or before, so that it doesn't get contaminated during the moving process, according to her report, to wrap a sheet around the face and head to protect the clothing from contamination by blood that might come out of the nose during the movement process.
A picture called Exhibit S to the 8th you photograph.
Yes, this is the rest of the clothing from contamination by purge fluids. That is, as after death, she realizes, and they realize things change in the body, and in the course of movement, fluids can come out of the nose and mouth, which include decomposition fluids. Remember, the body was there for about 15 hours for movement, during which time everybody would have blood air passages, upper air passage. So this was done. The decision was made not to remove the jacket at the scene, which could have been done. The decision made not to put the body and dress in the clothing with all the material on the clothing to a thick plastic, which is put into a body bag, which is then put onto the mortuary wagon. That mortuary wagon is brought down to the medical examiner's office, Dr. Lakshmanan's office, Dr. Pena's office. It's taken all out of the mortuary wagon, put on a stretcher, a autopsy table, and then examined. In fact, Ms. Lindemuth, Dr. Pena, and
Unprotected at this point.
It's
What are you doing, StreamYard? Hello? What are you doing?
the defendant's present with his counsel. The district attorneys are present. Before we begin, I take it you're ready to proceed, Mr. Brunon?
Yes, sir.
I just want to note something. It's been brought to my attention, and it's now been verified by some of the jurors. There are people seated, they're seated next to Mr. Dunn, who keeps commenting on the evidence as it develops, and the jurors have heard you, other people have heard you. If it happens again, those individuals are out of the courtroom forever. It's that simple. And you know who I'm talking to you, ma'am.
I understand.
Okay? It's real simple. All right, thank you. Mr. Brunon, you wanted to be heard as to the discovery issue?
I did, Your Honor.
Okay.
As I understand the issue, we're talking about the new theory or explanation that Dr. Bodden and Mr. Ford came up with Sunday to explain the apparently inconsistent facts of the blood deep in the lungs and...
Okay, can you hear me? Hey, Nancy. Okay, I know I'm having problems with my audio. I don't know why. Earlier, I was looking at one of my videos and I noticed that even when I'm not breaking up or I'm not having a lot of problems with the audio, my audio is lower than the court audio. So that I understand now why you guys can't hear me when I talk when the court is going on. But am I still like when court's not going on, am I still too low for you guys to hear? Because I don't know what else to do. You can hear me now when the court's not going on? Cuz as long as you can hear me, I mean, if I'm going to say something of any importance, I can. Well, of course, it's not important. It's just me rambling. It's not important, but you know what I mean. If I have any observations that I want to share with you, I can pause court. Um okay, it's perfect when pause court. Okay, it's perfect when the court is paused. All right, that's what I wanted to know. Okay. And of course, if I get upset during court, I scream. So you can probably you can probably hear me then.
Completely severed.
That's sort of the impetus to get this whole issue started, right?
But are we talking about information other than that?
Well, we're talking about how it fits into a pattern, and the pattern is it started with this missing box of evidence that was, I can't remember whether it was Mr. Blazer's.
By the way, this is outside the presence of the jury, and it's about a half an hour long. And then the next segment is about an hour, and it's Dr. Bodden again. And that should take us right up to the next trial. And I have the portal set, so we will go right over there. And it is Iowa v. Karina Cooper. And the name of the trial, they're calling it the Widow's Words Murder Trial.
Office, or Ms. Kenny Bodden sort of took responsibility for it.
Mr. Blazer.
And I think I sort of fine. And things do happen, and I understand that. And then all of a sudden, and I understand you are not responsible for the Henry Lee thing, and the court's made its findings. You were not the attorneys at the time, but the bottom line is I found a discovery violation on that. And now we have, in essence, what is the third discovery violation. Well, and maybe more on Dr. Bodden about giving reports to those reports, and then in turn over the process.
That, kind of a baseline.
Now, that hasn't been raised by the prosecution yet.
Well,
and I don't, if they think there's been a violation, they'll let me know.
Well, I'm sure that there were conversations between their experts that don't get memorialized. The nature of conversation is ongoing, and some of them are completely.
Turn this around. No, it wasn't just a conversation. It was a change of opinion. He changed his mind about the spinal column being transected completely versus partially. That's not just a conversation about an opinion. That's a change of opinion. No. Don't try to turn this around like it was an innocent conversation.
The type of thing is, so what do you mean by this? And, they're kind of filling in the blanks. So Monday morning when the first communication could have been made, and Tuesday when the information was revealed, and a box of paper priors that was revealed 4 months before the trial. So I mean, basically that's what we're talking about.
Come here. I'm right here. No, you have to come here. I have to go. It won't make it full screen. Dang it won't do it. Come here. Oh, there it is. Happy birthday! It's his birthday, guys. Mwah. I love you. Bye. Have a great day.
distinguish between things that might be factual in their nature. For example, a new slide that was developed or a new test, something that is more concrete and more factual in nature, as opposed to something that is hypothetical or explanatory, kind of a this is what may have happened information. And after looking at the cases, I haven't found a California case that deals with this kind of narrow issue, an expert's amplification of an earlier opinion. But there are numerous stand for the proposition that it is simply not necessary to reveal all of those communications. And one of the leading cases is a Bowersfield versus on matters within the expert's expertise, but outside of the expert's report, is not only permissible at trial, but the exclusion of such testimony may be reversible error. So, and as we discussed when this issue first came up, kind of unanticipated on Monday, the cases out of the federal system that deal with this more frequently in the nature of the beast and component, it doesn't, the experts don't even have to prepare a report for federal. But this type, as far as I can tell, been treated as a
Okay, it's obviously time to turn my camera off. Travis broke StreamYard. Wow, 39. Ours is October, will be 18 years. Wow, I can't imagine. I mean, we're going to be together forever cuz like when you get the right one, you just know. Like I cannot foresee, I mean, I'm sure everybody thinks this, but I cannot foresee anything happening that would ever tear us apart. That's just, we've been through so much. If he was going to leave, he would have been gone already. Just say that. All the illnesses and the surgeries and the almost dying and everything. Like, if he was going to be gone, he would have already left me. So, like, I cannot foresee anything that would, if he was stood by me through all that crap, he ain't going nowhere. But wow, 39 years. Wow. That's amazing. Yeah. Congratulations. That's crazy. Yeah, we got married late though. I was 38. Yeah, like, yeah. Yeah, we are, yeah, we're like, yeah, we're soulmates. If that's, I mean, I know that's like cliche, but we just, we work perfect, like puzzle piece perfect. Like, he's not officially he's been officially diagnosed with Tourette's, and I think he's autistic. That's not, he has not been diagnosed, but so like things that he doesn't get, like mentally, like things he doesn't understand, or like, because autistic people take things really literally, so like there are things he doesn't get because of that. Like, so have to explain things to him sometimes, and he has a hard time with reading comprehension. So if he's got, like, for instance, we got a hot tub, and we don't have it anymore because it was one of the inflatable ones, and a hurricane took it and threw it into our barbed wire fence because we emptied the water out because there was a hurricane, which that was a stupid idea because the hurricane took it and threw it into a barbed wire fence and it popped. We probably would have been better off leaving the water in it, but anyway. So, when we put it up, he had me read the directions to him because if he had read the directions, he would have had no idea what he just read. And then I've had cancer twice and I don't know how many surgeries, and he's been there and taken care of me when I was sick. So like we complement each other with me with the health stuff and him with the reading comprehension stuff. So like we fit like puzzle pieces, and and then when we don't need each other, like I mean, well, we always need each other, but like at night he comes home from work, like I'll be in the bedroom watching TV, crocheting or diamond painting or whatever, and he'll be in the living room watching what he wants to watch, and like we're just chill. It's not like we don't have to be like right up on top of each other all the time. We have our free time, and then we have our time when we do stuff. I mean, it's just perfect. It's just absolutely perfect. And like when you find that person, you just know. It's just so cool. And but I didn't find him till I was 38 years old. But when you have like he was worth the wait. Like when you find that person, and I wish I had just chilled when I was younger, but because I was like always looking for the husband. Where am I going to find him? Am I going to find him here? Am I going to find him there? Like every guy that I liked, I was like, is this the one? Is this the one? I wish I had just chilled and just enjoyed life until it happened. But no, I was always looking for a husband. But I got the best for me, like the best for me. Well, it would help if I would share my screen. I mean, I complain that he doesn't like to do little things that I like to do. He can be a stick in the mud at times, but oh yeah, I'm gonna turn my camera off so it doesn't crash. I hate that I have to do that.
Where, in that case, the defense lawyer refused to have his expert prepare a report, refused to really communicate what the expert's conclusion was, and simply stonewalled it. The court in that case, the trial court, allowed the expert and his associate to fully, that was appropriate in that case. Also, the court refused to allow the same expert to come back on Surabel after the prosecution had introduced evidence contradictory to the unrevealed report. And the court said because of the delay involved under 352 and because of the flat refusal to disclose any of the expert's report, the other case the court cited testimony concerning just not the appropriate circumstance. So whether or not it's a weakness, or at least another component, whether or not there was prejudice. At this point, the prosecution hasn't said how they were prejudiced by the delay from Monday to Tuesday, the one-day delay in learning of this information. We haven't heard how, if they'd heard it Monday, they'd have been able to do something that they weren't able to do because they heard it Tuesday. And prejudice, obviously, is a component in this. If there's no prejudice, there's no violation. So I think we need to have some amplification on that particular point. And coming down to the final, what are we going to do about it? 1054.5 says that exclusion, which the court is talking about, is the extreme remedy.
I mentioned exclusion is one of the remedies that is mentioned in the case law. I never said I was excluding anything.
Okay, well, okay.
Has yet to have been decided.
Well, then I misunderstood. I thought it was on the table.
Well, it's on the table in the sense that that is a possible remedy. I have never indicated that that was the appropriate remedy. It's something that people no doubt will ask for, and I'm prepared to deal with it.
All right, well, just briefly on that point, that's the extreme remedy. It's cases essentially disfavor that remedy, but the statute and the cases interpreting 1054.5, the court must try every other remedy short of that before that. And thus far, we haven't tried any remedy because we don't know what the prejudice is, so we don't know how to resolve any potential prejudice.
And I think I mentioned that. I don't know if you were in the courtroom, but that is the last and final and most extreme remedy. And I mentioned to the people before I decided, I have been asked at the bench to go ahead and make a decision, and I've indicated until the people sort of finish deciding what they're going to present to me, I'm not in a position to make that.
So maybe, to an extent, this may be a little bit premature, but I think establishing the principles so we all know what we're looking at and how we try to address it is important. But as I sat and listened to the testimony yesterday, it seemed to me that the prosecution's cross-examination may have mooted out most of the issue. Mr. Jackson said before beginning the hearing yesterday that he was going to only address the when and the where, kind of the surrounding facts of this new theory. So we assume that that's what would happen, but during the course of the exam, what is your explanation about the... Dr. Bodden again said that in trying to reconcile
StreamYard.
these seemingly inconsistent facts, it occurred to him that there may have only been partial transection and that this would not have been unheard of in the forensic realm because he was familiar with instances where the neck wasn't stabilized and a partial transection became a complete transection during transportation. So, it was, as we've referred to, as an aha moment. And the prosecution examined him about that, examined him about the nature of his theory, examined him about, well, when did you first come up with it? How did you first come up with it? What kind of a numbskull wouldn't have thought of that years or months before? And, kind of examined the entire area. So I'm thinking, what's left here? It's been challenged by the fact it's not in his report. It hasn't previously been discussed with any of the other experts. It's like something that just showed up at the last minute and therefore may not have that much examination. But certainly it's been challenged and reiterated before the jury by the prosecution's own initiative. So, again, we come down, steps can be used to deal with prejudice. I think that talking about finding some prejudice and finding some sanction is premature.
Thank you very much. Prosecution,
Just brief examination. Just first, a couple preliminary matters. That always sounds like over a theory of discovery violations, but as the court pointed out, this is the third one in the row, and I'd just like to first just briefly compare and contrast how the information that they get from our experts compared to what we get. I mean, we had this 2.5-page report that doesn't include the aha moment in it. They have bench notes, rough drafts of reports, test results, photographs, emails. They know that. I mean, we can cart it in little trucks, hand trucks, to show how much stuff they've gotten. We are asking the court to, there are a couple others, as the court pointed out, a pinpoint instruction that we can all address at the appropriate time. And kind of following the Lamb case that the court mentioned, we think that the defense should be limited on their ability to redirect Dr. Bodden on this issue, on the new AHA theory examination. Brunon, I think, is wrong when he says that Mr. Jackson mooted this all. Mr. Jackson's questions were directed, as he indicated, the court would be, surrounding when, how, why to this at this last moment, that sort of thing. And Dr. Bodden's answers went way beyond, in our view, answers to direct Jackson's questions and tried to his views and his rationale science. Mr. Bruno, we all know how Mr. Jackson on the science, the way to the talk, looking at the photographs, autopsies with respect to the spinal cord and whether or not it was transected, talked to some experts and the like on this. Even if we'd known on Sunday, even on Sunday, that happened. And in today's world of email and voicemail and all that, would have been very easy to do. Mr. Rosen knows that I talked to Deborah Robitaille and came up with a new bit of information, and I emailed him within a day or so. He's got the email. And for this, I want you to know, they could have done that. Mr. Plort advised us take advantage of this situation. And that's exactly what he did. And we think that there should be some remedies to this. And one of them one or more of the ones that I suggested, perhaps are the correct ones, and including perhaps not allowing Warner Spitz to come in and back this up at the last second. We would also ask the court to preclude that, or at least consider it. Thank you.
Thank you. Mr. Brunon, did you wish to reply?
That hasn't filled in the fact. Perhaps he could have talked to experts. Perhaps he could have looked more closely at the he could do it was 3 days over the weekend. No one has been precluded from doing that. And to posit these hypothetical things that we might have done or use it as a tactical advantage. I think the box of papers is really a red herring, and it's kind of, put it into context. There was a delay in producing it, but it still was produced 4 months before the trial began. So, and again, there was no particular prejudice associated.
And that's why the problem.
If there's no prejudice, there's no violation. I think that those things.
Oh, there can still be a violation, and it goes to the remedy.
Yeah.
Withholding discovery is a violation without prejudice. It's a question of what remedy.
I don't think we need to do that right now.
Sorry, guys. StreamYard isn't playing nice today.
That there is some specific prejudice that is inured to the people as a result of this one-day delay. To talk about jury instructions, to talk about limiting witnesses, to talk about anything in particular is inappropriate, because what happens is you're punishing the lawyer, but the detriment goes to the client. It puts us in a position where what are we going to do about Mr. Plord? If the court maybe...
Well, maybe Mr. Plord should have thought about his client before he made the discovery violation.
Yeah, this is something that the jury will say, well, that Plord is really an evil and despicable person. And it might not be in Mr. Spector's interest to have such a miscreant on the team. It leads to what I'd ask the court.
And again, Mr. Plord should have thought about that before he made the discovery violation.
What to do is wait and see what all of the facts are, and then we can discuss what the appropriate remedy for any exists.
Well, to some extent, I'm not going to do it exactly the way you want, but I'm actually prepared. I've been given obviously for how to science, because the federal law doesn't seem to hold the federal cases, and the reason is they're not interpreting the California statute. Those are statutes, or those are cases and decisions that interpret basically federal trial law, which are not controlling in this court. I would point out that the new discovery statute was not passed by the legislature, but instead was passed by the initiative process. It was the direct will of the people of the state of California, and the stated reason, quotation marks. If you read the Lamb case is really stands for a much greater proposition than you seem to believe it does. And they were very specific that the language in the statute means exactly what it means, that there's no wiggle room. They're very, very specific that the language speaks for itself. It doesn't need interpretation. It doesn't need to be pondered upon. It means exactly what it says. And let me just note for the record, you and I have known Mr. Plord before this case, and Mr. Rosen and Mr. Dixon, we grew up under a different system, and that system was the prosecution at that time that under both the California and the federal Constitution, that was a violation of the defendant's constitutional rights not to incriminate himself, and that giving discovery would do that. Well, the U.S. Supreme Court and the California Supreme Court, when the people of the state of California passed this initiative, decided that that wasn't the fact, and that defense discovery was constitutional and should be given. And I'm not denigrating anyone when I say I've been watching it since I was here when the initiative passed, that it is one that the defense bar hates, especially if you grew up under the old system. You don't like it, you don't believe it, and believe it's given very grudgingly. Everybody's going to get around it. It's just that's the way it is. That's just observation of someone who's been sitting here for 25 years, and I know that to be a fact. Fine, so be it. As I say, the majority of people, if they don't like it, but they understand that they have an absolute obligation to follow it. So the federal law is not controlling. What is controlling is the statute itself, and obviously a case like Lamb, which says we mean exactly what we say is printed on the paper. As to whether or not I believe there has been a violation, I have made my order. I have no doubt, and I say that as clearly as I can, that this was done to gain a tactical advantage. When Dr. Bodden testified, I keep little notes to myself, some testimony I've stated, little notes, not noting interesting things from my standpoint. And believe me, when Dr. Bodden testified as to that new thing, it wasn't just an aha moment to him, it was an aha moment to me. Because I said, let's see how the prosecution does with this one, because this is a major piece of evidence, and it's a major change in defense strategy. And if anyone is going to sit here and tell me, well, it's really not that big, it's just sort of a modification of a prior opinion, I'm going to say that's nonsense. I saw it for what it was, the prosecution was, and I believe what it was. This was very important, and for whatever reason, so don't put this on Mr. Plord by himself. He may have been in charge of it, but told me, he stood here in court and said, I discussed it with the other attorneys. So if you've made a bad decision, you made a bad decision. It's that simple. If you thought it was appropriate, you're wrong. It's that simple. There is a violation. To gain tactical advantage, to throw the prosecution off its game, to delay them in being able to gain information, to properly cross, and to delay their ability to believe that the exclusion remedy is wrong in this case. One, as I have stated before, as the cases have stated, as you have pointed out, that is an extreme remedy. And a judge who goes that route is walking a very fine line on a very, very, very thin ice. So I have looked at the timing aspect and whether the prosecution is able to recover. And frankly, as we wind down this case, and I'm going to get into it, we're losing an alternate today. I don't know if you've been notified, but we are losing an alternate because of an illness in the family. Tell you, even though we have 4+ months with all our alternates and jurors intact, once it starts, it tends to snowball. That is my observation from my years on the bench, and I am now, although we still have 5 alternates and the panel intact, I grow very concerned as this case becomes more and more delayed. And I don't know whether the prosecution is going to take advantage of the time to try to, consult other experts or whatever. We'll find out. But clearly there's a prejudice not only to them, there's a prejudice to the case. So I'm very concerned about what happened, and I do believe that a remedy is necessary and so egregious, and I think that it is, because of the reasons I have found that it was done. And I would point out, before I get to what the remedy is, I want to remind you that from day one, from the time that this group has come into the court as the defense, been yelling for their discovery. They keep saying, where are your experts' reports? Well, we don't have a report. And in hearing Dr. Bodden testify, I sort of wonder, why did it take so long to get his report in here? That's really a really good question, is this 2.5-page report that could have been prepared much earlier and basically came in, if not the last moment, sort of at the later innings. And I think this is just an instance, I think, of a determination to turn over everything at the very last possible minute. Bottom line, there is going to be a remedy. There is a violation. The violation is prejudicial, and there's going to be a remedy. The remedy is going to be, when the case is all done, I am going to draft, with everybody's input, pinpoint instructions pursuant to CalCrim, I believe it's 306. Just double check, which is the instruction that has been written and has taken into account the criticisms of the former CalJIC. It is 306, the former CalJIC instruction, because the CalJIC instruction was lacking in that it allowed a jury to draw an inference that they could view this on the guilt issue of the defendant, which can't be done. Mr. Spector is not a part of this. It's his defense team that put us in this situation, and he under law, is not allowed to be blamed for it, and the instruction will point out, and I will make it very clear, because I'll probably modify that as well. It doesn't go to the issue of guilt or innocence, but it does go to the issue of the prosecution's to present their case, and I believe it also goes, and they put it into context as to how they weigh that testimony. And because of that there's going to be an instruction, and we can all work on it together, and ultimately I'll be the one that determines the language that goes in. And this is the kind of thing that finally is going to deter lawyers, and it goes for both sides. I see prosecutions, not in this case, but I certainly have seen discovery violations from prosecutors as well, as I'm sure you have, where they play hide the ball. And the only way that we're finally going to put an end to this game playing in criminal trials is when there starts to be a remedy and judges don't look the other way. And I'm not looking the other way. So I'll determine the language when we're done. That's what's going to happen, and I hope that we're ready to proceed with the jury. The jury, by the way, is at the airport. Juror number 18, the last alternate, 14, I'm sorry, juror number 14, has a family member. I don't think I'll violate their privacy rights, but is seriously, seriously ill, and they have to go deal with it and cannot wait. They're distraught not only over the family situation, but obviously having put 4 months into this case and now not being a part of it, even if they didn't get to deliberate. So the court finds good cause. And alternate, juror number 14, the alternate, is excused for good cause at this time. I don't think, you know what, I gave everybody a chance to argue, and that's my findings.
Material.
Okay, if you want to respond to the thing about the lateness of the reports, you certainly may.
There's three things. One,
Okay.
Kind of throwing a conspiratorial net over the defense.
I didn't say a conspiracy.
No, you did. You said...
Well, Mr. Brunon, that's your language, not mine. I said I see a problem.
You said that Mr. Plort discussed it with the team members, and
That's what he said.
I want to remind the court what Mr. Plort did say, and I want to clarify that because I don't want to cut Mr. Plort loose, but he also told the court that he didn't discuss it with Mr. Rosen and myself or anybody else because we wouldn't have fully understood it. And well, I mean, that's what he said. And but beyond that,
we'll take a look. Well, go ahead. I want to find his direct language. Go ahead.
Well, I also want to tell the court the facts so that you're not basing it on some interpretation, trying to read something into it that didn't. I'll just tell you this. The first time I heard it was when you heard it, and the first time Mr. Rosen heard it was when you heard it. Mr. Plort is the science lawyer on this case, and he is handling the science presentation and the science confrontation. Okay. So to say that this was some calculated decision.
There is no way if because that's a very important thing. Like when they first started talking about it, I was clueless, right? But then I got it. Then I was like, okay, so what they're saying is if he wasn't standing close enough to have done it to her, how'd he get the blood spatter on his jacket? Because she did it, and then he was like, oh my God, and he rushed over to her, and she wasn't gone yet because it didn't completely transect her spinal column, and then she breathed out, and that's how he got the blood spatter on the jacket. That's important for the defense. That's the gotcha moment. That's the aha moment that can prove that he didn't do it. That's the Like, that's their gotcha. That's their, no, this is why he's innocent. I guarantee you Plord told the other attorneys. There's no way he didn't tell the other attorneys. I don't believe a word he says. There's no way he didn't say, oh my God, guys, oh my God. There's no way he didn't tell the whole team.
Is wrong, and to draw that inference is the court putting the thumb on the scales, frankly, and it just, there wasn't.
You know what, Mr. Bruno, that language is ridiculous. I find it offensive, and I'm letting you know I find it offensive.
Well,
I'll find the language that Mr. Plord stated to me. I'll show it to you.
Well, I'm telling you the direct facts, so you don't have to.
Well, that's fine, but what am I supposed to ignore his language and then you putting the scale on the thumbs? That is really insulting. I'll tell you something. You better withdraw that comment. You better think about it, and I'm just thinking about it. You better withdraw that
I
comment.
said it was akin to it. I'll withdraw it. It just struck me that you are looking for additional weight that isn't warranted by the facts, and I'm trying to tell you what the facts are. That's point number one. Point number two, I think the court is, again, with the issue of the alternates, we still have 5 alternates, and we're down to the last week of the trial. To suggest that the possible
I hope Mr. Bruno unpacked his toothbrush.
possibility of losing all 5 alternates and then a juror is somehow a prejudicial fact that's cognizable in this court's calculation, I think is speculative, and I think it's inappropriate, and I think I'm entitled to observe that.
Fine.
And the final thing, to say that I'm going to use this circumstance as a general deterrent to the criminal defense bar and the prosecutorial bar, again, is beyond the scope of...
Absolutely he did. 100%. 100%.
what the court should be considering. I think the appropriate considerations are what are the facts in this case and what's the appropriate remedy in this case, and not to send a message to the bar in general. And that sounds like what the court was saying about you're going to put an end to the so-called gameplay. So I think that we're not here to establish lessons. We're here to try to resolve discrete issues in a discrete case that has its own particular facts. So that's all I wanted to say.
Okay, I agree with you that I'm here to resolve the issue in this case. I am making an aside, and it is no more than an aside. Discovery violations need to be addressed firmly and appropriately.
Your Honor, may I make just one brief comment?
If you wish.
Yeah, I do. Thank you. I don't want to spend a lot of time because I think Mr. Bruno has been very articulate this morning, but I think I need to echo a portion of what he said, and that is he is absolutely correct. I don't recall Mr. Plord saying that he discussed it with me or Mr. Bruno, and I can tell you this, I did not see Mr. Plord Sunday, I did not see Dr. Baden Sunday, I did not speak with Mr. Plord Sunday, I did not speak with Mr. Baden. I have my own very keen reading all home. And Monday morning, and Mr. Bruno is absolutely spot on. The first time I heard, and I know the first time Mr. Bruno heard the testimony was...
This judge knows how to control a courtroom. I wish whatever judge school he went to, I wish they would send every judge to that school, because I don't know if it's the contrast, because we just watched Bev for how many weeks? He's amazing. I don't think I've ever seen a judge as good. Well, Darrow and Judge Penny, but this guy is amazing. Why can't all judges be this good?
That if in fact the court makes whatever decision it makes regarding what Mr. Plord's motives were or what they weren't, and he is a member of this team and we embrace him, if he made a mistake and if he made a violation, as the court has pointed out, I think that we really have to be very careful to step away from making the finding of the violation, making the finding of the prejudice, and getting to the remedial considerations, because True, Mr. Plord is one of the team members and he represents Mr. Spector, but I'm just concerned that the jury does not punish Mr. Spector for what in fact Mr. Plord did if the court in fact finds that Mr. Plord overstepped his bounds. That's all.
Well, I accept that, and I don't, if you and Mr. Brunon tell me you weren't a part of it, that's fine. I only have what the statement was by Mr. Plord, and I'm going to find it, because it's gotten to be a point, and nobody spoke up at the time. If you tell me now that he was misspoke, that's fine.
I didn't even hear him say it.
I'll be glad
I'm telling you those are the facts, and I would get up on that witness stand and say
Fine,
they're the facts.
and I accept that you would do that. I am telling you what I was told.
I understand.
Okay? And it doesn't change, even if I find that Mr. Brunon and Mr. Rosen did not know about it, it doesn't change the fact that a member of the team did do it and the team is responsible. So that's that, but it doesn't.
Still a discovery violation, no matter whether he told the other ones or not. And like I said before, it's not punishing Spector, it's punishing Plord, and he should have thought about his client, what it was going to do to his client's case before he did it.
Change what happened in the case. You can't say, well, he did it, we didn't, so it doesn't count anymore.
You're not thinking of giving the vicarious liability instruction to the jury, are you?
Not at this time.
Okay.
Actually, what I want to do, let's go ahead and bring the jurors in. I'll locate this. I don't want to delay the case any more than we have to, and we'll get started. Did the prosecution wish to be heard?
The only issue is I won't do it now, but if Mr. Plord, I don't know if he's intending to get into the issue of the transection of the spine. If he does, and I feel like it goes further than simply the when did you come up with this, then I will object on scope grounds. I was very clear about what I did and what I didn't do.
I know, I'll be honest with you, you told me that's what you wanted to do, and that I have no doubt that was your intent. I'm not sure that the way the answers came out, and I found that they were appropriate to the questions that were being asked, I'm not sure I can limit it. The bottom line, and I probably will not, the bottom line is, as I said, the witness will not be excused.
Yes.
All right, thank you. The jury is coming out. Can we deal with it later? Sure. Okay, thank you.
Oh, come on. Oh, there it is. I was fixing to say, I had this one ready. Why is it not working?
All right, the witness previously sworn is still under oath. The jurors and the alternates, with the exception of number 14, are present. Dr. Bodden is present, still under oath, and you may proceed.
Thank you. Good morning, Dr. Bodden. We had Exhibit S8 on the screen before, and do you have that before you, Dr. Bodden?
Which is S8.
That's the scene where the Lana Clarkson's body is being prepared for transport. Okay, we could get S8 there. You were talking before we left about generally the procedures when a body is moved, that sometimes precautions are taken in certain ways, and in this particular case it appears that a sheet or cloth was put over her head to do something. What was that designed to prevent, as you understand it?
According to Ms. Lindemuth's report, a coroner's white sheet was put around the face and head of Ms. Clarkson to prevent any fluids from coming out of the mouth and contaminating the rest of the clothing.
Okay, and in talking and understanding what happens in a case, do you sometimes rely upon reports such as criminalists that work for medical examiner's office, both in your experience as well as in your private forensic practice?
Yes.
Okay, so you've reviewed those. Those are part of all the reports that were given to you in this case. Is that true?
Yes.
Okay, and what was your understanding from the photographs and the reports as to how the body was wrapped up and taken to the medical examiner's office here in Los Angeles County?
The reports from Ms. Lindemuth is that she removed certain evidence from the remains of Ms. Clarkson at the scene from 6:10 to about 7:10 for about an hour, then discussed in a report whether to remove clothing at the scene or put the white sheet around the face to prevent contamination of the clothing, they decided to, after talking to the supervisor, to put the white sheet around the face, remove the body, placed it in a plastic, placed it into a body bag, removed the body to the coroner's office, and about 30 minutes later was in the coroner's office, placed on a table.
Okay, let me stop you there and
That was
back
the
up.
procedure.
Now, was it your understanding that the hands were wrapped or not wrapped before?
The hands were not protected in the paper bags that I'm accustomed to.
What's the significance, if any, of that?
Well, the purpose of putting paper bags around hands is to prevent any contamination of the fingers and hands, because they're often important when a crime has been committed.
Now, Ms. Lintemuth, the criminalist, documented in her reports and records that she did certain evidence collection from the hands before the body was
Yes.
transported. Was that appropriately documented in your view as far as her report was concerned?
Yes, Ms. Lindemuth lists that she had removed, she did a gunshot residue test on the hands. At the scene, she put an acetate tape and lifted up trace evidence and from the front of the jacket. She
At this point, excuse me, doctor, at this point I'm going to object on hearsay grounds. Unless this is being used, it appears that the witness is simply reading from a report. Unless this is being used as the foundation for some opinion, it sounds like Mr. Plord is simply asking him to reiterate to the jurors what Ms. Lintemuth did, and he's doing so through a hearsay report. It's inappropriate.
Doctor, did you use this information to arrive at any opinion in this matter?
Yes.
All right, the objection is overruled.
You were talking about Ms. Lintemuth. Let me focus your attention on this, Dr. Bodden. You talked about a tape lift. Did Ms. Lintemuth also document the collection of something from the hands other than gunshot residue? Just a yes or no on that.
She did.
I'm sorry. Okay, and did it involve blood spatters on the backs of the hands and wrists?
Yes.
Okay, and I'm going to ask you this question, and for counsel's edification, it's from and the court, volume 30 of the transcript of this trial, page 5299. Did Ms. Lintemuth indicate that she took swabs from the left wrist and right wrist? Did she indicate that?
Yes.
And did she also indicate that she saw these blood spatters on the wrists and hands?
Yes.
Okay. And did you take that into consideration in arriving at your opinions and conclusions in this case?
Yes.
Okay. And you mentioned in some testimony, I think that was elicited with Mr. Jackson, that there was some problems with the photography. What was trying to be photographed as far as you could understand as it related to problems?
She wrote down and stated in a testimony that she took swabs of the blood from the wrists and had the back of the hands photographed, asked the photographer to take photos of the blood of what she considered blood spatter on the back of the hands, and those photographs didn't come out properly.
Okay. Is that significant at all?
Well, it's significant in evaluating the blood spatter.
Okay. If we could have that last exhibit back up again. Before we leave the scene, based upon the way that the body was transported, is there any problem with evidence coming off the body or off the clothing that's on the body that could affect anything that you could look at in this case, the way they did it?
Yes, yes.
What is that, if you could explain that to the jury?
Some evidence is transient. It's transient because it fall off or get lost during transport. The transport process is very important in the forensic sciences. So by putting a person in a body bag without protection of the clothing or the hands may permit loss of evidence from the body into the plastic sheet.
Okay. Now, it's your understanding that the body was taken to the medical examiner's office and was collected at a later time, is that correct?
Yeah, it was brought down and promptly that same evening examined at the medical examiner's office. Ms. Lindemuth says that at 8:20, that is, she starts out about an hour earlier, the decedent was...
Objection, this is non-responsive narrative at this point.
Sustained.
Dr. Bodden, with reference to
and purge materials from coming out of the nose and mouth and contaminating the body or the clothing.
now, would the sheet protect the head from moving around and causing movement of the spinal bones and so forth where the fractures were?
No.
And you mentioned that this bullet wound went through the spine and it broke some bones in the spinal column, is that correct?
Yes.
This is beyond scope. Beyond the scope of my cross.
I'm going to overrule the objection. Let me answer.
Now, when those bones are broken, do they have are they sharp, are they not sharp? What could they do, if anything, because they're broken?
The edges of the fractured bones are sharp.
And what effect, if any, can that have on the spinal column?
Well, that would be an additional risk of injury to the spinal column during movement of the body from the chair to the morgue wagon to the table yeah.
When the body was taken to the coroner's office, does Ms. Lindemuth describe how the body is processed and how the clothing is done? Does she say anything as to how, whether it was moved, gingerly or not so gingerly or anything such as that?
Yes.
What did she say?
She says the body was flipped onto its side, onto the left side, for purposes of photography, so photos could be taken of the body and further examination.
Before the clothing was removed, is that correct?
Before the clothing was removed, yes, sir.
And also after the clothing was removed, is that correct?
She was moved around on the table before and after the clothing was removed, yes.
Now, Dr. Bodden, in your experience, you've done autopsies in traumatic death situations, automobile accidents, knife wounds, gunshot wounds. Have you ever seen injuries such as the ones that Ms. Clarkson has had where there's been partial or incomplete transections of the spinal cord?
Yes.
Overruled. I'll allow it.
Yes.
In other words, where some part but not all of the spinal cord was cut or damaged? Is that?
Yes.
Okay. And in this particular case at autopsy, at the time of the autopsy, when the procedure was done, the dissection was done, the spinal cord was completely severed. Is that correct?
It was found to be severed when the autopsy reached that part of the examination, yes.
And does that mean that it was that way when the shot was fired or immediately thereafter?
No.
I want to move on and get to the issue of the fingernail or the acrylic of the nail on the left thumb, and ask that Exhibit PP be put up, which is Defense Exhibit PP. And I'm going to ask that another, basically a clearer photograph of the exact same picture be marked, Your Honor, because simply I'd like the doctor to look at this, and it just shows the detail better than the photograph that we have. I don't know if we should mark it the same number or whether we should just renumber it.
This would be V11.
V11. Okay. V11. Doctor, I'm going to show you this photograph and ask you, is this basically a glossy, more detailed, a little bit clearer photograph than Exhibit PP, essentially?
It's the same photograph as PP, but it's sharper, certainly, for me to look at.
Okay, and what is the significance of that piece of acrylic that was, that is shown in this portion of the photograph here that you have, that you also have a better copy of?
The significance to me is that it's evidence, it indicates that the right thumb was on the trigger at the time of discharge of the weapon, because I've seen various thumb injuries before under those circumstances.
Now, with reference to the evaluation of the case materials in this case, did you ever review the laboratory records of a Dr. Lynn Harold as it relates to this tape lift that was taken by Miss Lintemuth?
Yes.
Okay, we could have Exhibit I-6 on, and then we'll go back to PP in a minute. Okay, showing you I to the 6th. Is this a photograph of the tape lift that was recovered from Lana Clarkson's skirt area, basically somewhere in the midsection?
Yes.
Collected by Miss Lintemuth and looked at by Dr. Harold at her laboratory sometime after she got looked at this case?
Yes.
And did you consider her notes and her report regarding what she observed on this, in particular anything with relationship to any nail or nail-type material?
Yes.
What did you consider, and why did you consider it, Dr. Bott?
I considered Ms. Harold's description of a fragment. I think she circled, this is the circled fragment, the small fragments up here, yeah, in which she says when she looked at it under her microscope that it was a white opaque fragment, question mark, part of fingernail polish. And that's exactly what the tip of that acrylic is. It's white opaque fingernail polish.
Now, this doesn't appear to be the entire missing portion, is that correct?
No, it's a fragment. It's a shattered fragment.
Why wouldn't this be the entire size of what's missing? What would be the discrepancy?
Well, this is a little fragment. There's about a quarter of an inch by an eighth of an inch or so missing. You know, so the tip of the finger. Could you go back to the previous?
Sure. Let's go back to the previous exhibit.
Yeah. The only part missing, remember, the whole fingernail is perhaps an inch. This is a tiny tip of the fingernail, the kind that I cut off when I try to shorten my fingernails. And this white opaque is part of what's called a French manicure. A French manicure in which white opaque fingernail polish is carefully placed on the tip, just the exposed tip of the finger that's growing, of the fingernail. The underlying fingernail is intact. The fingernail isn't broken. That's the underlying fingernail, and the only thing missing, and this is exactly what Dr. Harold described. And she says in her note that she's going to investigate all. She didn't.
Okay. So this is, she described it in her notes as a one white opaque fragment, question mark, part of fingernail polish. You mentioned something about these French, what did you call them?
French manicure.
And you know something about this, doctor?
We have, medical examiners have to know about articles of clothing and how fingernails are done. so we can describe things that we see at autopsy.
You don't have that on your hand?
I must admit, I did Google this yesterday also.
Okay. But you've run into these
Yes.
issues before, correct?
Yes, my wife will
And she
use it
gets
occasionally.
Okay. In any event, the white portion is actually something that's painted on and there's polish. Is it a?
Yeah.
What's the process as you understand it? I don't want to go into the whole details, but as you understand it.
The nail is cleaned and the base coat
What is happening? We're doing a French manicure tutorial now? What?
put on it to make it smooth, and then the acrylic in this instance doesn't have to be an acrylic, it could be a regular. Is
Acrylic on. What the fudge?
painted on it, placed on it, painted.
At this point, I'm going to object. There's no foundation. If the basis for this witness's foundation for nails and polish and et cetera is Google, I don't think that's appropriate for expert testimony. I mean,
I think
sort of lay.
you know what, if it really gets to be a question, you can call an expert, but for right now, I'm going to let him indicate his opinion, all right?
Yeah, I'm sorry, I'm not an expert. However, I just want to make the point that then the fingernail polish is put on it, and special polish is put on the tip. You see,
The white portion.
the white portion.
The white
is what
opaque portion.
What I'm concerned about is a special thick fingernail polish that gives the appearance of the manicure, the French manicure, and that what Dr. Harold describes, the fragment, describes this exactly. And she was concerned about that. She saw that. She says, fingernail, question part of fingernail polish, and indicates that she's going to ask the investigating officers whether she should.
Objection. This calls for speculation.
It's in here.
Excuse me.
I'm going to sustain the objection at this point.
Move to strike the last portion.
Last portion.
Sorry.
Well,
Okay. Even that's in her notes? I think that's in her notes.
What is in her notes has already been testified to. His impression of Dr. Harold's impressions or her
this
considerations.
impressions is inappropriate. It's all right.
Oh, okay, no, no, I'm not saying it. Let's go. Frank, what? Okay. This portion here is
Nail polish.
Okay.
That's painted on to the tip of the nail.
Lord, man.
okay, and getting back to,
It isn't
and is it your impression or understanding that when this breaks, it doesn't necessarily break off in one piece?
It can shatter into tiny little pieces, as was picked up on the tape impression that
Objection. That calls for speculation. That assumes facts, not an evidence that anything from this nail was actually picked up on the tape. The notes are.
It can come off in one piece. It can come off in a partial piece. It can come off in 1,000 pieces. It can do all kinds of stuff, and he has no idea what the he's talking about.
Clear that it's a question.
Okay.
You can ask it in a different form. The question is sustained.
Okay,
The
in any
objection is
event,
sustained.
Doctor, your experience is that when people trigger weapons in these self-inflicted situations, this type of damage to the fingernails can occur. Is that correct?
right. It goes along with every action. There's a reaction. The thumb is pressed against the trigger, and the weapon recoils and toward the shooter, and the fingernail or the thumb can be injured by the metal trigger guard around the trigger.
Okay. We could have a minute here. Yes. Now, in the photograph that we've had remarked, the same one here, if you could comment on the clear photograph, if you could show the jurors the area of the thumb that you think was somehow impacted by the trigger guard or weapon during the course of this event.
May I, Your Honor?
Yes.
Okay. On the fact that we have the number, I'm going to make sure. V up to the 11.
What I'm referring to is this little this tiny piece here. Missing. This little piece is different. That's where the nail polish is missing. It's here. That's missing. It's a shadow, a little bit of a shadow.
Your Honor, if there's no question pending, I'd appreciate it if all testimony be limited. I don't want the...
I agree.
Thank you.
Doctor, before you go back, we're going to do this in the reverse order here. On this particular photograph, finger, and does there appear to be a little bit of damage to the tip of the index finger also on this that you use this exhibit?
There's a little bit of what appears to me to be normal wear of the fingernail on that tip. Yes, so a little piece of the, tiny piece of the white polish has frayed off in the normal course of wear and tear.
Okay. I want finger on the photograph. Is that the other little blood spot that people have been talking about that you mentioned before?
Yes.
Okay. Now,
90-degree angle, direct blood spot.
okay. Now, I'd like to ask you some questions about the weapon that was recovered, the gun that was found at the scene, 38 caliber Colt Cobra. Is there anything about the weapon that is inconsistent with it causing damage, such as the damage to this acrylic that we've been talking about?
No.
I want to have you look at the a video of the gun being shot, and you've seen a video of this of a Colt Cobra 38 being shot before.
Yes.
Okay. And this is exhibit B7.
Just to clarify, I think Mr. Ford just misstated. I want to make sure the record is clear. He said the gun being shot. It's clear that this is not the Colt Cobra that's in evidence, not the weapon that killed Lana Clarkson.
Agreed.
All right, thank
and
you.
it's a Colt Cobra, a similar one.
Okay, go. Take your finger off the trigger when you do that, please. Yeah, go.
Okay. Now, Dr. Bodden, a couple of questions here. If the gun was being held as you believe it was, being held with it inside the mouth, the recoil would be in the same direction. There'd be no real difference in the recoil. Is that correct?
That's correct.
Okay. And does a gun like this have enough of a recoil to cause the injuries to this acrylic or the damage to this acrylic?
Yes.
Okay. And the recoil, as far as the sight of the gun, is it consistent with the particles that were found in it, the teeth particles that were found in it? In other words, hitting the post and natural tooth that was found on it?
Yes, and it would be the site hitting the natural tooth after the composite had been blown away, exposing.
Are you kidding me? What the fudge? What is happening? What is it doing? Okay, I gotta reload it. Ugh. The. Ugh. I do not feel like dealing with tech issues today. We got too much to do today. We got the new trial. We got the Brian Koberger hearing. We got too much to do today. Okay, so the acrylic wasn't okay. Like mine, I did my nails the other day. Um, I've got tips glued onto my nails because they were so short. So I've got like a plastic tip glued on with acrylic over it. But some people get acrylic put on that go out past the nail to make the nails look longer, and it's just acrylic itself past the nail. The picture of her nail, the it was so some people when their nails grow out, like if mine never grow out because I do them myself and I suck at it. So mine will break or completely come off as a whole nail. Um but some people that go to a licensed nail tech and knows what they're doing, they will grow out past the tip or just their own nail will grow out to the point that they just have acrylic over their real nail. And that's the way hers looked in the picture. It looked like just like a little sliver of the nail of the acrylic, I mean, had come off of the top of her real nail. So it looked like, to me, it looked like sometimes if you hit something with your nail like that, it will crack the acrylic and then a little section will fall off. And that's like, oh man, it's over when I did it. But that's what it looked like. It didn't look like um it did anything to the natural nail at all. So I don't understand how that only broke the acrylic over top of her nail. How it didn't get the real nail too. If that's how the acrylic broke off. That's why I was saying, how come we don't know what happened? Like, I want to see a picture of her nail before she even got to his house. She could have broken that little piece of acrylic, could have come off. She could have hit it on something at work. And it could have, that little tiny edge of the thumbnail that was gone, she could have lost that anywhere. But they keep making it a big deal, like she did it when she pulled the trigger. We don't even know if she pulled the trigger. Probably she didn't, right? So, and this guy knows nothing about acrylic nails because you don't put a base coat on before you put the acrylic on, and it is not polish. Right, right. There's so many ways to break acrylic off of your nail, and for it to be just for the acrylic to be knocked off the top and the underlying nail not to be damaged. I don't think she damaged it on the gun. She might have damaged it struggling with him to get him off of her, but I don't think that theory is like stupid. Stupid. It's just stupid. Now I got to figure out where we were.
Attempted to do that.
Okay, but apparently that something happened where there was some movement of that. Is that correct? The purge came out?
Ms. Lintermuth indicates that after the body was put on the autopsy table in the medical examiner's office.
Why is my pec all wonky today? Okay, we're going to take a short break before we go to the other trial so I can try to fix stuff. And of course, as always, we will get caught up, so don't worry about us being late for stuff. I will make sure we won't miss anything. But I gotta clear some cash and some cookies or something, because I'm not dealing with this all day. I would think so. Yeah. Like even if, let's say, they were like pseudo rehearsing, like if he was like, well, let's pretend, or let's act, let's do a pretend scene and act, like even if it was something like that and he was holding the gun and accidentally pulled the trigger, yeah, that would be manslaughter. Oh, Teresa, that sounds amazing. Ooh. Okay, let's try to figure out where we were.
Working that night, that a lot of purge fluids that accumulate mostly in the
We weren't talking about fluids.
sent to Dr. DeMeo.
We're talking about nails.
You didn't know where the teeth were found at that point or anything? A video of them being... On this particular photograph, you can also see the
I'm referring to is this
Dr. Mann?
this tight
up to the 11. Here, if you could comment, and on the photograph, if you could get up and show the jurors the area of the thumb you think was somehow impacted by the guard or weapon during the course.
I want to see the picture of the nail.
May I, Your Honor?
Yes.
Okay. On the back of that, we have the number V up to the 11.
What I'm referring to is this little
Dr. Mann?
this tight piece here. It's missing. This little piece is where the nail polish is missing. It's here. That's missing. It's in a shadow, a little bit of a shadow.
No, there's no question pending on. Appreciate it if all testimony be limited. I don't want the...
I agree.
Thank you.
Doctor, before you go back, we're going to do this in the reverse order here. On this particular photograph, you can also see the index finger, and does there appear to be a little bit of damage to the tip of the index finger also that's on this, that you can see on this exhibit?
Yeah, there's a little bit of what appears to me to be normal wear of the fingernail on that tip. Yes, so a little piece of the, tiny piece of the white polish has frayed off in the normal course of wear and tear.
Picture here, I want to jump to another subject and then continue on with the fingernail. Peter, area, is that the other little blood spot that people have been
Degree angle, direct blood spot.
questions about the weapon that was recovered, the gun that was found at 38 caliber Colt Cobra. Is there anything about the weapon that is inconsistent with it causing damage, such as the damage to this acrylic that we've been talking about?
No.
I'm going to have you look at the a video of the gun being shot, and you've seen a video of this of a Colt Cobra 38 being shot before.
Yes.
Okay. And this is exhibit.
Just I was mistaken. I want to make sure the record is clear. He said the gun being shot. It's clear that this is not the.
Hi, guys. And now it's going to buffer.
Okay, go. Yeah, go.
Okay. Now, Doc, if the gun was being held as you believe it was being held with it inside the mouth, the recoil would be in the same direction. There'd be no real difference in the recoil. Is that correct?
That's correct.
Okay. And does a gun like this have enough of a recoil to cause the injuries to this acrylic or the damage to this acrylic?
Yes.
Okay. And the recoil, as far as the sight of the gun, is it consistent with the particles that were found in it, the teeth particles that were found in it? In other words, hitting the post and natural tooth that was found on it?
Yes, and it would be the sight hitting the natural tooth after the composite had been blown away, exposing the natural tooth.
Okay. And when the composite or the non-natural tooth was blown away, did it cause damage to the inside of the lips right in front of those where the composite material would be?
A little bit of pinpoint hemorrhages could have been caused by those fragments of composite. Most of it went out of the mouth.
Okay, but it hit the inside of the lips, kind of went out all in the same process, that immediate recoil process, correct?
Yes.
Now, would that further suggest as physical evidence or physical injury that would suggest that the lips were lightly closed over the barrel of the gun?
Yes, that the inside of the lips had to be exposed to the outgoing fragments of bone, composite.
And did Dr. Pena describe the same injuries in the autopsy report? These inside the lips, little, he called it pseudo-stippling?
Yes, he did, and he described that. That's what I'm referring to also.
Okay, and you both looked at that when you were at the autopsy, is that correct?
Yes.
Okay, and was that part of the evaluation, the oral cavity evaluation that basically suggested to you that the gun was inside the mouth, the fact that there was injury from these particles of fake tooth or crowns that injured the inside of the mouth before they went out?
Yes.
Along with all the other findings, is that true?
Yes.
Now, the Mr. Jackson asked you if you were at the scene, so you saw the stairs and the area there, is that true?
Yes.
That was before you knew any of the, you didn't know where the teeth were found at that point or anything such as that, is that correct?
That's right. I saw the scene of death after Ms. Clarkson's body had been removed and after the crime lab had removed everything they could find that was of evidentiary value.
Okay,
And that
now,
was about 38 hours after the shooting.
Dr. Bodden, I want to now get back to, I've got a photograph of the buttons, which is Peter the 11th. This is one of the photographs you were shown yesterday. I'm going to show you this one, then I want to mark another one next in order after that. This is the one that Mr. Jackson was asking you about regarding the tissue on the sleeves and so forth. Did you rely upon the observations of tissue on microscopic slides as it relates to this particular jacket that was worn by Ms. Clarkson that was taken off at the coroner's office?
Yes.
When the description of the microscopic slides that show tissue, do they show blood? Is it your understanding they show blood on these slides also, or just tissue?
The microscopic slides prepared from these buttons, which I think weren't done until March, until January of this year, January of 2007, took little fragments from each of these buttons on the left the left forearm, and those, because they look to us, I saw this in May of '07 at the Sheriff's Department when there was an examination of the evidence, and myself and some other of the forensic pathologists noted the possible presence of tissue on the buttons. And the only way to be certain whether it's tissue would be to look at it under the microscope. And what I mean by tissue is human material from the skin or just under the skin or in the mouth, human tissue. And that was removed, as I recall, around January of this year.
Okay.
And then the microscopic slides were sent to Dr. DeMeo and examined.
Okay, and would this tissue, would it have anything to do with the type of tissue that comes out if somebody shoots themselves in the mouth and there's no exit wound and there's blood in the tissue that comes out of the mouth?
Yes, that was our concern about this.
Okay, and was it your understanding that the areas that were selected were areas where there was tissue so that you could find out what kind of tissue it might be?
Well, to find out if it were tissue, if it came from the mouth, and it was tissue under the microscope. It proved to be under the microscope, because it can't be unusual, and it could be tissue, but under the microscope, this turned out to have nuclei and cells resembling material from the oral cavity, tissues from the oral cavity. And what was also noteworthy in the microscopic slides is there was no blood around it. There's no free blood around it.
Okay. All right, and I'm going to ask that another exhibit be marked next in order, and this is picture ZY9B-30.
W11.
I'm sorry, I missed the number.
W11.
Thank you. Dr. Bond, while we're getting this exhibit up there, did Ms. Lintemoot describe in her report in the handling of the body, talk about the issue of this purge that occurred?
Yes.
Okay, and did she document in her report the fact that there was a purge that came out of the body at the medical examiner's office? And did she also describe in her report and records where the purge went and what it covered?
Yes.
And in evaluating the evidence in this case, did you consider that report and the fact that this purge event occurred?
Yes.
Now, before we talk about where it went and what was it, a purge? You mentioned it was fluids that basically secretions that somehow build up after death that are common. Is that correct?
Yeah, purge fluids are fluids that accumulate mostly in the nose and mouth after death as the tissues inside the nose and mouth begin to decompose and begin to break down because of lack of oxygen and blood flow and because of bacterial activities. And this can also be augmented in a situation like this by blood and other fluids that are flowing into the oral cavity and the nose area because of pre-existing trauma. So what we as pathologists and Dr. Lintemuth as a criminalist have to be careful of is to avoid the purge fluids contaminating the body or the clothing. And she attempted to do that.
Okay, but apparently that something happened where there was some movement of that. Is that correct? The purge came out?
Ms. Lintemuth indicates that after the body was put on the autopsy table in the medical examiner's office for further examination that same evening, they were working that night, that a lot of purge fluids that she tried to prevent came out of the nose and mouth after the body was flipped onto its left side, and the left part of the dress was left part of the jacket was contaminated by the fluids flowing down from her nose and mouth into the jacket, and she tried to describe that.
Okay, and did she describe it as going a certain distance?
Yes, she said it went down toward the elbow area, but didn't go down to the buttons.
Okay, and getting
I'm going to check, Your Honor, that assumes facts, not an evidence.
I believe that was her testimony also, Your Honor. It was also.
What are the facts not in evidence? What is it assuming?
I need to think about what the answer was. I'll withdraw it for the time being. If I can think of it,
Okay.
maybe in 10 minutes I'll have an epiphany.
All right, thank you. You may proceed.
Subject to the epiphany that Mr. Jackson will have, I'm going to ask you some follow-up questions because we're going to wait for that. If we could have W11 up again, is this picture, Dr. Bond, a photograph of the jacket area around you were talking about, just a different photograph that was taken by the Sheriff's Department or some other agency?
Yes.
Okay, and so the area where this tissue was, is it this white stuff here that we're looking at in Exhibit W to the 11?
Well, actually, it's the material on the buttons themselves.
Okay.
And the material, I tried to point out, sort of a little reddish material on the buttons.
Okay. Were these buttons like in a pool of blood or anything such as that?
No, in my opinion, and in interpreting what Ms. Lindemuth wrote down, it's my opinion that the purge fluids didn't get near to that area.
Okay, and the purge material, we'll just use that term, does it include tissue? Does purge have this tissue in it?
Not tissue after she'd been sitting for about 15 hours or so, and any tissue would have been removed from the fluid by the natural settling of the tissue and its incorporation into fibrin and blood clot that develops while the blood is in the mouth, so that what comes out is blood without red cells and platelets and white cells, which are largely clotted and don't flow out with the purge fluid, and tissue doesn't flow out with the purge fluid.
Okay, and I take it that you deal with this phenomenon of the purge because basically this is something that naturally occurs after death, and you have to know the difference between something that's there because of a purge versus not. Is that true?
Yeah, that's true, yes.
Okay. And let me ask you this, Doctor, with reference to the sleeve and the tissue and so forth, did your observations of the jacket and where these tissues and the slides that you looked at from the tissues, did that play a part in your overall evaluation of this case?
To my evaluation.
Okay. Ending of the come out of the mouth when the shot is fired, whether there were any of these tissues, such as you saw in Lana Clarkson's jacket, on the pants of Mr. Spector that were evaluated by the crime lab. Was there any found on that?
There were no tissue found on Mr. Spector's clothing, certainly not on the pants.
Not on the jacket?
Not on the jacket.
Not on the shirt?
Not on his shirt.
Not on his shoes?
Not on his shoes.
Not on his cuffs, his left cuff?
No.
His right cuff?
No.
Inside, outside?
No.
Did you take that into consideration?
Yes.
As far as the blood spatter, was the fact that there was no blood spatter on Mr. Spector's shoes considered?
Yes.
His pants?
Yes.
His shirt?
Yes.
And then the distribution or pattern of blood that was found and the type of blood that was found on his coat, you considered that also?
Yes.
Dr. Bond, I want to now move to the jacket for a minute and ask that B9 be put back up. You have a copy of that before you.
Thank you.
Mr. Jackson was asking you whether or not you hold yourself out to be a blood spatter expert, and I believe your testimony was that you don't necessarily do that. Is that correct?
Yeah. I'm not a blood spatter expert.
Okay. Do you ever consider the patterns that blood make as far as evaluating a case and consider information from other blood spatter experts, that type of thing?
Yeah, I consider distribution of blood on clothing as part of the expertise of a forensic pathologist. I don't measure the blood spatters as the fine mist or 1 millimeter or 2 millimeters. That would be beyond my expertise. But the distribution is a toxicologist. But I evaluate, and it's my job to interpret what the toxicologist finds.
Okay. So you looked at information regarding the blood spatters that were on Ms. Clarkson's hands, is that correct? You looked at what was available to you?
Yes.
The type of spatters. You looked at the spatters that were on her clothing, is that correct? You considered that? You considered the distribution of blood, the pattern of blood that was on Mr. Spector's coat, is that correct?
Yes.
And to the extent that something is a millimeter or more than a millimeter, you leave that to the blood spatter experts.
Beyond my expertise.
Mr. Stewart James, you looked at this jacket that's in this particular exhibit. You looked at this jacket with Mr. James, is that correct, Stewart James?
Yes.
Mr. Kish?
Yes.
Dr. Henry Lee?
Yes.
You've reviewed that joint report that those three gentlemen did regarding the blood spatters, is that correct?
I'm going to object, Your Honor. This assumes facts not in evidence.
Approach the bench. Ladies and gentlemen, the testimony or the question and answer dealt rely on the report from that.
We're going to stop there. It's a good place to stop. Write down. We are on what part? 201? Okay. So, everything's been asked and answered over and over and over and over. They did the same thing in the OJ trial. To the point that it was just like, can you please quit asking that question? It was like, seriously? Seriously? Are you seriously asking this question again? You asked it 3 days ago 5 times. Why are you asking it again? Like, can you write down the questions you've already asked so you don't ask them again? Okay, so now we are going to go to the Widow's Words murder trial that I know nothing about. I didn't even know it was starting today. So we're going to go there. It will redirect you. I had it set for 10 because that's when it was supposed to start. We went a little bit over. And I'm going to do a little something to try to make StreamYard a little bit happier. So we're probably going to be a little bit later than that. But it won't be by much. And we won't miss anything. We'll start at the beginning. And then we can zoom through sidebars and stuff. So, I will see you there. And you will portal over. If you're not joining us for that trial, I will see you again in the morning for more Phil Spector. Diddy verdict was reached. I'm assuming guilty. Judy, was it guilty? Which we probably won't be able to wait for her answer because her chats are sometimes delayed quite a bit for some reason. But I'm sure we'll find out when we go to the next chat, to the next stream. So, okay. So, that will portal you over there. If you're not going to join us, we will see you tomorrow at 8. Yeah, and Friday is 4th of July, so no stream Friday. But we will see you tomorrow at 8 for Phil Spector. And be kind to people. Love your family. Jesus loves you, and so do I. And I will see you bright and early in the morning, or I will see you in a few minutes at the Widow's Words murder trial. Bye, guys.